continue your speech, you pause and ask them for a few people.
Hey George, I'm also going to mute you and unmute you when you guys are going to speak.
No, they should mute themselves.
Or you can mute yourself.
They'll not be able to unmute themselves.
Oh, so
Like there is a mic icon on your Hangouts call that you can just click
Just at the top of
to
the
switch
call,
off your mic
top of your screen.
temporarily.
okay, fantastic.
Awesome.
Awesome. So
All
please
right.
unmute whenever you have to ask points of information, etc. And please mute again after that. Okay, guys, without further ado, we now invite the first speaker from Proposition.
Here.
All eyes are on you, the plaintiff, the prosecutor, the accused, his lawyer, the crowd, all expecting you to give a verdict that is favorable to them. You've been there for hours, working on the same case for years, drawn out, and a backlog of cases spanning over decades, delayed because it requires people to appear in person in order for you to proceed with the hearing. This is something we want to stop on side proposition, and we believe that incorporeal trials are the best way to do so. So what do we stand for on side proposition? We believe to win this debate, we'll have to prove to you firstly that this increases the efficiency of the trial process, and secondly that it better protects the victims, witnesses, and the accused. So what do we envision this to be on our side? We believe that trials will be in the absence of any lawyers, witnesses, defendants, plaintiffs, or a crowd, and will just be the judge or the jury present there deciding on the sentence. We believe that these hearings will still be recorded and transcribed, and these will be available and accessible to the public in a transparent fashion, which means that it is not very likely that this tends to be a very opaque or there are chances of corruption on our side. We believe that cross-examination and witness hearings, instead of being in person and face-to-face, would just happen over, say, documents and statements and in the form of video clips or voice notes, right? And the judge can always ask for newer evidence or newer statements and facilitate cross-questioning as and when he needs. Or all he has to do is probably send an email or intimate it through message, right? So, and we believe that this will significantly improve the trial process on a whole. So what am I going to be talking to you about today? Firstly, as to how this helps improve the efficiency of trials, and secondly, as to how this protects victims, the accused, and the witnesses, and facilitates their rehabilitation. Before which, I would like to take a POI, if any.
Yeah, so more cases mean more videos and more transcription, and auditing will simply mean it's more time consuming. How do you make the court process more efficient in developing or populous countries?
We believe that the existing court process in itself is far more time consuming than what we are proposing, which means that we're definitely improving the situation as whole. We believe that viewing videos and reading through documents are things that happen anyways in status quo, but what we do is decrease the amount of delays and the time taken with physical hearings, with the requirement of having these stakeholders and actors being present at court. This is something we reduce, and which is why we believe that we're better off on our side. Moving on to my first argument as to how this improves the efficacy of trials. I will be addressing two main areas under this. Firstly, is that this eliminates chances of human error and biases on the part of the judges. So that there are multiple factors that play into a judge's sentencing, right? And some of these are very subconscious in nature. For example, the very appearance or aesthetic of the plaintiff or the accused can make a lot of difference to how, which the judge views the case, and which the judge proceeds to look at the entire issue, right? What the person looks like, his race, religion, or anything that he can see visibly by just looking at the plaintiff at court, right? How a person is dressed, how he or she speaks, how his or her lawyer speaks, the language. These are things that can really affect the decision making of the judges. Something which rather shouldn't, right? Because, and even if the judge just looks at it in an objective way, we believe that these are things that the judge subconsciously takes note of, right? And this can definitely change the very way in which the judge looks at the case, and can all facilitates like inherent biases and error to occur on their part. And secondly, we believe that right now, in the case of physical hearings, we have a crowd present, right? And we believe that when judges have eyes on them, a crowd which is noisy, right? Or say a crowd which actively supports one side of the case. And when the judge can actually see the reaction of the crowd and what their reaction to what he or she is saying, we believe that this will definitely impact the sentence he or she is about to pass, right? If a crowd is predominantly white, right, and the case is against the black man, we believe that the judge will definitely be influenced by the crowd and by how they react to circumstances there, and if not consciously, very subconsciously. So now what do we do on our side? On our side, we prevent the manifestation of these biases, or at least reduce them. Why? Because these hearings are not face-to-face anymore, right? They're through documents or voice notes, and we believe that the kind of hostility or bias or stigma that comes through physical hearings is not present when you do it through when you do it through documents or videos or voice recordings, right? Which is why we definitely help that on our side. Secondly, as to how this decreases the time and resources required for the different parties to participate in a long trials. The reason a lot of cases do not come to court is because of the sheer amount of time and resources required to have that trial, right? The amount of time you require, which is often in years, right? Because you have to have hours and hours of trial where each side argues and presents their case, right? And these timings and or dates on which these trials are held often have to be suitable to all parties, which doesn't always happen, which means that the case keeps postponing and gets delayed beyond a point, right? And we believe that this really taxes, say, attorneys and lawyers who have to spend hours to prepare for that presentation, spend hours again to present that information, which otherwise can be done with a click of a button, or just like presenting a video or typing out a document, which is far less time consuming than that, right? And what happens as a result of this? When individual cases reduce in time and are less likely to have delays, we believe that a judge can handle more number of cases, and that more number of cases can be pushed for and resolved at a faster rate. And another thing that really reduces on our side is the amount of resources required, right? You're no longer required to travel to the court. You're not required to arrange for transportation. You don't even require to be in the same city in which the trial is taking part, which significantly reduces the resources needed for a trial, the reason for which in status quo, a lot of poor people do not really take this forward. So now what does side opposition have to tell you? They'll have to tell you as to how there are net positive outcomes that come solely out of physical trials that does not occur on our side. With this, I am very proud to propose.
Hello? Are people ready? Hello? Are people ready for us to start?
Hey, George,
Yes, we are ready. Sorry.
Sorry about that. Okay. Ready, get going. Okay.
Ladies and gentlemen, when you sentence someone to prison, not only do you put them in a cage, but also you permanently relegate them to the damaging status of ex-convict. On side opposition, we abhor the scenario in which you do this to an innocent person, and thus we're very happy to stand against this motion. In this speech, I will bring you two pieces of substantive, and my second speaker will give you our third. Firstly, I will explain to you why this motion is principally illegitimate. Secondly, I will tell you why more innocents end up in prison as a result of this motion, and why that's particularly bad. And thirdly, my second speaker will explain to you why physical hearings are the only means and one of the most important means for alleged criminals to defend themselves, especially when they are innocent. But before that, I'd like to deal with some rebuttal. I have two broad questions to ask in rebuttal, and I will analyze each one individually. Firstly, does the policy that side government propose improve the efficiency of court cases? And secondly, do they better protect victims under their side of the house? Under the first question, we heard in the last speech that physical court hearings, mostly because you need to find the time that is suitable for both criminal and victim and judge and lawyer, you often have it postponed because it's very hard to find the time that is this suitable. Panel, we think this is absurd and it is ridiculous. Firstly, we think that if you're going to send someone to prison for a decade or even more, it's the prospect of not giving enough time to actually allow for a sensible trial is absurd. Because if that person is going to spend a decade in prison, we don't think 1 week is too long a time to wait for that person's trial.
I'm really sorry, but my DPM can't hear you.
She has been messaging
on the chat, so just please wait for a second. I think it's an internet issue on her side. Just one second. Elakia, can you hear me?
I can hear you,
Yeah, I can hear you, but I'm not able to hear the fellow speaker. I'm so sorry.
Yeah, that's okay.
I'm not sure what the issue is, but I'm not able to catch a
You
lot of
want to be closer to the mic, like come closer to the laptop. That might help.
And Elakia, can you please rejoin quickly?
Yeah. That might help. Could you say something so Elakia can check? Sorry about this.
No, it's actually not.
It's actually not very clear.
Can you hear me now? You can't hear me now.
I can hear him, but I'm not able to make out when he talks a little faster while he's giving a speech. I'm not able to make out a lot of stuff. I'm very sorry for inconvenience, but I think it's an issue with the mic or something.
An issue with the mic. Okay.
Okay, we're just gonna go forward, and you can continue from where you stopped.
Yeah.
And Elakia.
So what's that?
Hello?
Did you say something, Jaya? Because then I didn't hear anything.
Hey, so I'm saying we should just go forward, and I'm really sorry for the interruption. I think you can continue from where you were speaking. And Elakia, you should try your best, and we'll talk later. Okay, just give it your best shot.
Okay, I'm so sorry.
Okay, Odie, you can restart from where you were.
So can I just start again? Because I'm not quite sure where I was. She didn't
Start from the beginning of your rebuttal.
But she didn't hear either, right? So it makes sense to start again.
Jaya, is it okay if we start again? Does that make more sense?
Yeah, that's okay. That's perfectly fine.
Okay.
Really
From the beginning.
carry on.
Ladies and gentlemen, when you sentence someone to prison, not only do you put them in a cage, but you also forever relegate them to the damaging status of ex-convicts. On Team Wales, we abhor when this is done to innocent people, and that is why we're very proud to stand against the motion in question today. Thus, we bring you a three-part case. Firstly, we will explain to you why side government policy is principally illegitimate. Secondly, we will tell you why more innocents are put in prison under their side of the house and the harms that come of this. And thirdly, my second speaker will explain to you why physical hearings are amongst the only tools which innocent alleged criminals have to defend themselves in court. But before I do that, I'd like to deal with some rebuttal. In response to the previous speech from the first speaker of government, I'd like to ask two simple questions. Firstly, does their policy make the court process more efficient? And secondly, are criminals and victims and judges and lawyers better protected under their side of the house? To address the first question, we heard in their analysis that the court process often takes a very long time because it's hard to find a time which is appropriate and which is suitable for all the lawyers and all the judges and all the jury. Therefore, it keeps on getting postponed, and so it makes most sense to do it in their way. Panel, we think that this is not an important argument in today's debate because if you're going to sentence someone to 10 years in prison or even more, we think that 1 week, 2 weeks is not too long a time to wait to find an appropriate time to ensure that you can get a sensible, suitable and adequate hearing. So we don't think that the argument that time is an issue, we don't think that stands in today's debate. But moving on to the next question, whether they better protect victims and criminals and lawyers and judges under their side of the house. Firstly, we hear that physical appearance affects the verdict of a judge. That is to say, that if a person is black or white or Latino, that may affect whether the judge marks them as innocent or guilty. Panel, we say that this is entirely true, it's entirely possible, right? But the problem is that does not change on the government's side of the house. Why is this the case? We think because of the fact that documents containing information about the victim, about the criminal in question, often has information such as race, information such as gender, information that will very well, or could very well, alter the outcome and alter the verdict of a judge. And this still happens under their side of the house as well. So they don't solve the problem of bias based on race. But moving on, the second bit of analysis we heard under better protecting criminals and victims is that a lot of times the jury, if the jury is of the predominant race, that is to say white people, for example, and the judge sees that that is the case, they often feel pressure to make the verdict that better suits that group of individuals. We think that this is absurd because firstly, if a black person, just for an analogy, if a black person was coming under questioning in front of a white jury, the fact of the matter is that you may very well have black friends in the crowd as well. So there will very much be both black and white people in the scenario, and so that should balance it out. But even if it doesn't balance it out, I think it's absurd to say that judges who are ratified by the state, who have been through university processes and have been through processes to ensure that they're actually fair, that they will be influenced and swayed by like having 2 or 3 more white faces in the crowd than black faces. We think that that's absurd, so that point does not stand in today's debate. But moving on from that, let's talk about my substantive material. Why do we think that their policy is principally illegitimate? Firstly, we would say that physical trials allow the criminal and actually force the criminal to see the effect of their crimes on the victims of those crimes. That is to say, when the criminal kills a man, they cannot look at the woman who is now damaged, the wife who is now heartbroken, the children who are now forever distraught as a result of their crime. We think that this is principally necessary in any system of law and order, and the fact that side government take this away, we think is principally abhorrent. Second reason why we think their policy is morally illegitimate is because if a judge is to sentence someone to prison for a certain number of years, or put them on death row, we think that judge should be able to look into the eye of the person whom they're sentencing to prison or putting on death row and know that they're doing the right thing and be able to know that they're doing right by their conscience. This is particularly important because in the world as we know it, there's a lot of bias in the judiciary. That is to say, as some judges may very well be racist. And so if a racist judge now no longer has to look into the eyes of the person who they are unfairly sentencing to prison, who they are unfairly saying should be killed, we think that it makes it much easier for them to do so. And we think that's extremely unfair, and it happens on the government side of the house. Now, and thirdly, under our principal arguments, we think that there is a certain symbolism in public sentences. There's a symbolism in seeing people confess their crimes to the public. There's a symbolism in physically seeing the person who killed someone's family, or physically seeing the person who killed your family, who killed your father. There's a symbolism in that, and we think that it does not exist on the government side of the house. And on that ground alone, we think that their policy is principally morally illegitimate. We do not stand for it in today's debate. Moving on to my practical arguments. But before that, are there any points of information from side of government? No points of information?
Sir, how is the policy going to specifically affect witnesses?
how will our policy specifically affect witnesses? We think that it'll affect witnesses in the exact same way it does in the status quo. That is to say, they come up, they give the witness statement that they're going to give, and they go back to their seat. We don't see what the point in that question was. Moving on from that, what is our practical? Why do we think that this policy being proposed by side government harms innocent people and is more likely to have innocent people ending up in prison? Realize, panel, that in the status quo, many prisons have lots of incentives many governments rather have lots of incentives to put people in prisons. Take, for example, the fact that governments get free labor from prisoners. That is to say, they often have prisoners create manufacturing chairs, and they have prisoners doing work in the prisons. Free labor, I wouldn't say slave labor, but very much free labor. So they have that incentive to put them in prison. Governments also want to make it look as though they're being harsh on crime to make the community feel safer. They have that incentive to put people in prison. Furthermore, you have judges and juries who are just racist and just biased, and also have that incentive, that racist incentive, to lock people up just by virtue of their race or their color or their gender. We think that side proposition creates a policy which also proliferates this tendency for harsh sentences and that are completely unfair. And we think that this is an extremely bad thing, given that there are already so many reasons why judges often put people in prisons unjustly. Now, how do we know that side government policy makes it more likely for people to get harsher sentences than they deserve? It's because judges no longer have to see the person whom they're condemning. They no longer have to see the face of the person who they're who they're giving 10 years in prison. We think that when the judge no longer has to look into the eyes of the mother of three, whom they just sentenced to a decade in prison, when they would otherwise have sentenced them to community service, we think that is the instance when punishments are much harsher and much more unfair to the criminal in question. Now, and this happens all exclusively under the of the house. What are the problems of imprisonment that abound as a result of side government policy? Firstly, ex-convict status. We think that when a person has the status of ex-convict, it makes it hard to find jobs. It makes it hard to integrate properly into society as a result of people thinking that you're a mass murderer or you're insane or you're an insane arsonist or something along those lines. It makes it harder to integrate into society. Secondly, gangs. We think that many people when they go to prison get caught up in gang violence, which by virtue of being initiated into those gangs in prison, and it becomes very hard to get out of those cycles. Thirdly, we think you lose money, because if you're going to be in prison for 10 years, that is 10 years you would otherwise have been working, 10 years you would otherwise have been getting money to provide for your family. Panel, these are three substantive reasons we think they completely harm the lives of individuals under side government policy. We are very proud, we are very happy for a guilty person to go to prison. But when an innocent person is forced is punished for something they did not do, we are completely opposed to that. For that reason, we're very happy to oppose the motion. Thank you.
Should I mute it? Yes, I think so.
Thank that speaker for that speech, and now I invite the Deputy Prime Minister.
Just one second. Okay, I'm done. Panel, we are appalled that today our opposition seems to think that decisions that judges make should depend on what the judge feels when they look into the accused's eyes. We think that kind of claim is morally unjustified and absolutely ridiculous, right? We think that a person should go to jail and should get the sentence they deserve for the crime they committed, rather than what kind of emotion a judge feels when you look when they look at the accused. We think that's a ridiculous case for them to make, and we think there's no justification for it. So, what has side opposition told you thus far, right? They've come up here and made some claims about how our policy is illegitimate. They've come up here and told us that the delays that we claim exist in today's court system don't actually exist, when the reality is that an average public defendant gets to spend about 7 minutes with with the accused in each case that he takes up, right? We tell you that in light of those facts, that side opposition's claims that these issues don't exist and these issues are not solved by by our policy is absolutely ridiculous. So let's deal with what they've given us one by one, right? So let's look at their principle. They came up here and told us that this policy is principally illegitimate because in the absence of a physical trial, the criminal is no longer forced to see the effects of their crime, right? What they don't take into account is that that an accused person is not a criminal until they are convicted, right? And that they make that assumption throughout their case. We think that's inherently problematic. The another thing that they don't take into account is the fact that victims often do not want to see the people who committed a crime against them. Rape victims may not want to see the people who raped them, right? They not want to be in the same room as the people who caused them that much physical harm. They don't take that emotionality on the side of the victim into account at all, right? And we think that's inherently problematic because now they cause even more harm to a person who is already damaged, to a person who is already sustaining physical and emotional trauma because of the harm that they have faced in the recent past. We think that's inherently problematic on their side. Then there's this repeated assertion on their side that by looking into the eye of the person that a judge might be sending to jail for 10 years, the judge is going to suddenly change the decision they make and the verdict they give and maybe give a less harsh sentence, right? We think that's an inherently problematic claim for them to make simply because we don't believe that decisions about sending a person to jail and the duration of their sentence should be made on such a split second of emotion that the judge faces, right? They tell us that it's also easier for them to send people to jail when they are racist or when these judges are prejudiced. We tell you that prejudice is exacerbated on their side simply because a judge who is biased against black people is probably going to feel even more biased when he directly sees the black person in front of him, right? We think that's inherently problematic and they haven't addressed that. Another thing they came up and told us is that there is symbolism in the public seeing a rapist put away and in the public seeing a rapist confess his crimes. We tell that you do not use an accused person's reputation to enact symbolism in a society, right? We tell you that a person is not a criminal until he is convicted. You do not use his reputation, you do not use his time, and you do not use the way people perceive him as symbolism to engineer social change. We think that is principally unjustified. They have to explain that to us. We think that's a huge flaw in their case. Another thing that side opposition came out here and told us in the way of outcomes is that more innocent people end up in prison, right? They told us that for some reason governments want free labor, as a result of which they want to send more people to prison, right? And we tell you that that's a ridiculous claim in itself. We don't see how they made it. They also told us that it makes it harder for people who have been sent to jail to reintegrate into society, and they put up a couple of issues about how these people lose time in society, that they have a gap in their CV. We tell you that none of that actually changes on your side, right? What happens is that the people who are accused of a crime and are convicted are still sent to jail. What changes on our side is that the people who are accused and are going to be acquitted no longer have to face a social stigma because they ended up in the stand that was meant for an accused person, right? We tell you that's the difference. We tell you that there is no other change on their side and that those outcomes that they claim are completely baseless. So what has side proposition told you that opposition hasn't dealt with, right? They told us that physical appearance and manner and bias that is based on the part of the judge doesn't actually exist and it doesn't change. Like we tell you that that's not essentially true. Even when you have information about a person put before you on a sheet of paper, that is essentially different from when you actually see that person. And if you are going to make a biased decision based on the person's race or their gender or their financial stability, you're going to make an even more biased decision when you see that person standing in front of you. We think that's inherently problematic. They also told us that the aspect of public influence that we brought up in our PM speech doesn't actually exist. We tell you that that is completely false, right? Simply because when in a courtroom there is massive public support for one side of that trial when the public reaction to the proceedings is so obviously favoring one side of the trial. That kind of reaction influences the judge's decision. We think those influences should not be present, right? Because these are people's lives we're talking about. This is a person who might go to jail for 10 years for a crime he did not commit, or might go to jail for a longer period of time simply because the judge is acting based on the reactions he gauges from the section of the public present in the room. We think that's completely unacceptable, right? Another thing we didn't deal with is how we told you that witnesses they often don't want to be physically present in the courtroom, right? On our side, we tell you that takes away from the element of fear that a witness feels, right? Especially if you were a bystander. The witness now feels that they're less likely to be harmed later on due to the fact that they testified against an offender. And we think that's very important simply because now you have more evidence to support a court case, and we have more concrete facts to help a judge make a fair decision. We think that's very, very important and a big claim on our side. And that greatly helps our case, right? Another thing that we told you is that the accused person is less ostracized, right? We live in a society that often brands you as a criminal even when you are only an accused person, that brands you as a bad person even when you've been acquitted, right? We think that's the kind of problem we solve on our side simply because there is no physical proof of you being in that box. We think that actually makes a huge difference in the small ways to a person's life. So now what does side opposition still have to tell us? They still have to tell us how they are going to solve all these issues that we've tagged on our side throughout the course of our 2 speeches, right? With that, we are very, very proud to propose.
We thank the Deputy Grand Master for that speech and now invite the Deputy Leader of Opposition. Whenever you're ready.
Panel, in society, we have people who need to work twice as hard for what they have. These people are the Blacks, the Latinos, the poor people. This policy makes it so that these people are robbed of the right to defend themselves to the judge and jury on the basis of their humanity. We believe that this is morally abhorrent, and we bring you. And in my substantive, I will talk to you about how these are the people who need to use every line of defense that they have available to them. But firstly, my rebuttal. I'll be asking questions in my rebuttal. Firstly, does the model that they propose actually solve the problems that they're talking about? No. Secondly, which side gives fairer trials? And thirdly, is symbolism actually important in terms of these trials? Firstly, does the model actually solve the problems that they brought up? They brought up 2 problems in their first speech, which is the problem of efficiency and the problem of the appearance of the plaintiff affecting results. Now, the problem of efficiency, I'll give you 4 reasons why their model does not combat the problem of efficiency. Firstly, the cross-examination in media in terms of video files, transcript, is more time-consuming than actually having the take place in person with judge and juror. So this is more time consuming. Secondly, it reduces efficiency because you have to wait for new evidence to be presented rather than the judge or the lawyers just being able to question directly there and then. Thirdly, this means that you have to carry out a trial separately or carry out individual interviews separately and then send it to the judge and jury for them to deliberate rather than everything just happening in one go. And fourthly, they said that it's less efficient because it will take more time for people to travel and take part in the hearings and the trials. But we say this still exists under their side of the house because you still have to travel to give evidence. You still need to travel to have the hearings in the first place that you then send to the judge and jury. So this problem is not solved with their model. Secondly, the appearance of the plaintiff will still show. This is the problem that they have. But nowhere in the model did they suggest that the race, sex, or background of the plaintiff would be hidden. So this means that the judge and jury will still have full access to the race of the person, sex of the person, and their history. So they will still make a biased account, except this is worse on their side of the house, because the bias will be blind bias, and you won't have the appeal of emotion that people can make in order to combat this and combat the moral constraints of the judge and jury to make their case. So this is worse under their side of the house. Second question, which side gives fairer trials? The first speaker said that they will be able to do more trials because there won't be that open conversation between the lawyers and the defendants. This means that people are not able to present their case. This is what the first speaker said. And when people are not able to present their case, yes, we agree, you'll be able to sentence more people and have more trials take part. But which side is fairer? Compare our world, where everyone is allowed to make their case and everyone is allowed to defend themselves to their full extent and is sentenced based on that, to their world, where more trials take place, but people are not allowed to give their own case. We believe that we give fairer trials and are less likely to send innocent people to prison or give wrong sentencing. And fourthly, is symbolism actually important? They talked a lot about the fact that victims may not want to be there to see their perpetrators. Well, we say if they don't want to be there, they don't have to be there unless they're being questioned. But we say for the people who do want to be there, this symbolism is absolutely important. Because for the mother of a child who has been killed in cold blood, she wants to see the person who did that to her being put away for life in prison. We say this symbolism is absolutely important because you give the choice to the victim. You give a choice to the families of whether or not they want to see the justice being served. And we say that when a society sees a murderer being put away, it shows the society that justice is being served. And this is absolutely important symbolism. Society. Now on to my substantive point. We believe that everyone should have the right to defend themselves in any way possible, and this can only be achieved by the form of a physical trial. Now, this is in line with policies that are already in society at the moment, right? We allow people to plead the Fifth Amendment if they might say things that are self-incriminating. We allow people to stay silent and not speak because we agree the defense is absolute, because they're allowed to take whatever measures possible and able to defend themselves. We believe that in the same way, the defendant should be able to use their body language, to use an appeal to emotion to show that they are innocent. And this is very important in a number of situations. First, something that's been very clear all through the bench today is that there is racism in the judge, there is racism in jury, and there is systematic bias. And we believe the defendant should be able to defend themselves in any way possible, and the appeal to emotion is the best way to do this. But I'd like to stop to answer POI if there's any.
When opposition claims that eye contact can change how harsh of a sentence a judge gives, why is it that you believe that that same eye contact cannot lead them to make a skewed judgment?
We believe that any judgment made by seeing the humanity of a person and seeing what your sentence will do to them will never be unfair, but will only be in line with what that person deserves. So if you have a mother of three, like they said, you are more likely to give a fair sentence that allows her to be a good mother and allows her to get back to her children if you make that eye contact and see what is wrong with them, rather than judging blindly on what they did. Now back to, if we're talking about someone who has already had the odds stacked up against them because they're a black man in a jury of white people who are already against them in the first place, then that appeal to emotion is what trumps that bias, because it allows them to combat the moral constraints that the jury already has, and allows them to combat the pre-existing judgment they have of black people by showing their humanity, by showing them that they're innocent, and even if they're not innocent, showing that their sentence need not be exacerbated just because they are black, that they deserve the same sentencing as any other human because they are human first and foremost and not black. This is important. It's for innocent people who have the odds stacked up against them because they're really unlucky and have a lot of evidence against them. So for all intents and purposes, they seem guilty. But their body language that shows they are innocent, the appeals to emotion that show they are innocent, that give you that intuition that they are innocent, are what will give them a reduced sentence, or what will put suspicion in the minds of the jury to say, we need more evidence, or we need to make sure that this person is innocent before we convict them. We believe that this is what's most important in helping people who are in minorities, helping people who are unlucky and have the odds stacked up against them. You do not get this under their side of the house, because in their world, people are not human. They are just case files. They're just mock trial. They're just trials with the voice there. You do not get the fair trial under that side of the house. Panel. Team Wales stands for a world where everyone gets a chance to defend themselves in every way possible and look in the eyes of the people they've hurt, and judges look into the eyes of the person they've committed to die in some cases. Proud to oppose.
I thank the Deputy Leader of Opposition for that speech, and now invite the government.
Yeah, just a second.
Yeah, can switch on the camera then?
Hello, can you guys hear me?
Yeah, we can.
Yeah. Panel, we think it is illegitimate for our opposition to pose a burden so high as to say that there will be no innocence which will get convicted. We say that is something that is happening in status quo. We say that is something that they will not either solve, and we say that that is something that both sides cannot solve in the first place. Panel recognize that the blame that they have been pushing us on so far is that innocence will get convicted. Okay, but that will happen on both sides, and how are you going to solve that is something that our opposition hasn't proved, and something that isn't really relevant in this debate because it doesn't really concentrate on the direct topic of how these incorporeal trials are going to change that. So what am I going to talk about today? Firstly, I'll talk about the issue of which side is more appealing to victims and witnesses. So then I'll talk about which side provides efficiency, and then I'll talk about which side reduces the human error. Coming on to the actors which are victims and witnesses. Panel, recognize that we told you that more victims will report. We told you that when these rape victims suffer a psychological pain when they see the person who has abused them, then that is something that they need. Can be excused from. We say that they do not really need to be physically present there, and our side provides them. We heard no response from that or about that from our opposition. Secondly, what did we say? We say that more witnesses will be able to report, because now you don't have to come to the court. You don't have to leave your office. You don't have to leave your office. You don't have to lose your job. You don't have to lose a payday. And that is why we think that this is a more efficient process in our side of the world. We heard no response in particular to that from our opposition. But what did we hear from our opposition? They said that judge has to wait for the next evidence, and that is why it's time consuming. Panel, recognize in status quo 2, they have to wait for the next hearing. That is to say that if a jury thinks that the evidence is insufficient, then too they have to wait for the next hearing, and the next hearing happens days after. We think that that is something which is not mutually exclusive, and that is something that happens on their side too. Whereas what we did say was that all the formalities will be eradicated on our side of the house. We say that the time will be decreased by eradicating all the formalities that have to be presented in a trial. Will save time in our side of the house. We heard no response on that. Secondly, they said that they need that witnesses need to travel in order to send the evidences, which we say is ridiculous, right? Because they can send it through email, they can send it through their lawyer, and that is something that is not particularly concerning in this debate. And we told you how this allows these people to have quicker means to send the information, to send relevant information to trial, which does not happen on their side of the house. Thirdly, what did they say? They said that everyone is allowed to have defense on their side. Again, not mutually exclusive. And on our side too, lawyers will be the same, documents will be the same, evidences will be the same. What will change is the physicality of the people in the trial. And we think that is not such a big deal, and actually that creates benefits. And panel, for all of these reasons, we win the clash on efficiency. Then what did we hear about? And then we got to know about something known as symbolism. They said that they made a whole lot of issue about symbolism and how is that going to help them. First of all, one response to that: judge and judiciary to generalize should not be influenced by any factor. That is to say that if a victim pressurizes them, or a rich person pressurizes them, then we do not think that is a jury which is independent. And panel recognize that symbolism will actually influence judge's mind subconsciously. That is to say that they will be subconsciously influenced. On our side of the house, though, we do not claim that we'll totally eradicate this influence. What we do say is that this influence will be much reduced, because now you cannot directly see the people. You cannot now have your judgmental bias against them, because you are now just having documents. You are now having evidences, and you can judge upon the basis of that. And for all these reasons, panel, we think that the whole point of symbolism doesn't stand. Before I go on, I'll take a POI. Seeing none, I'll continue. So coming on to our arguments, panel recognize that from the Prime Minister, we told you how this will create more efficient trials. Now, then our opposition came up and said, well, if a person is going to get jailed for 10 years, then the trial needs to be perfect. Again, documents will still be there, evidences will still be there. They haven't told us why the physicality of these people are so important that it will change the whole decision from not guilty to guilty. Panel recognize that is something that they have not stated in all of their two speeches. Second response to that: all you're talking about is something known as felonies. That is to say, serious crimes. What we say is that a huge proportion of these crimes are contributed to misdemeanors. That is to say, not so serious crime. Panel, in United States of America, a marijuana arrest is a person is arrested for marijuana in every 50 seconds. That is to say, a person is arrested in every 50 seconds, and that tells you how much court cases the judiciary has. And in order to solve them, we say that these trials need to be more efficient, and these trials can only be efficient if we remove the physicality of these people, if we remove the people's if we remove the condition of people going physically be present there. And that is why we think that is so important in this debate. Then they told you about ill effects of innocence getting convicted. Yes, we accept that innocence getting convicted is something bad, but how are you going to stop it? Never answered. Now, then we told you that how the judge is going to save him or herself from personal bias. No answer. Now, what did we hear answer on? They said that it was principally legitimate for these people to be physically present there because there can be biases. Now, panel, recognize how ridiculous that sounds. On our side, the decision will be announced to public. That is to say that when, for example, in the case of Filiando Castile, when the police officer was found not guilty, there was social unrest because public got to know about the decision, and that will happen on our side too. We do not see why there will be certain bias in our side, because the decision will be made for public. The trial will be made for public, and that is something that we have been stating from the Prime Minister, and they haven't responded to any of that. And that is why we say that public reaction will still be there. Public will still get to know the decision. Public will still get to know about the trial. What changes is that these people do not need to be physically present there in order to present their case. Panel, for all of these reasons, we win and vote for team proposition. Thank you.
Thank the government for that speech and invite the opposition.
Check the mic.
Am I audible? Yeah. Yes.
Yes, we can hear you.
When the state, the police, and the jury is stacked against you, because of the color of your skin or the God you pray to, you must be able to look into their eyes and demand justice. You must be allowed to use your body and your conviction to defend yourself because everything is stacked against you. That's essentially what we are telling you from opposition, that we believe in the right of self-defense, and we believe it's absolute to the point where you should be allowed everything to defend yourself, including the emotions you invoke in the minds and in the hearts of judges who are judging you. In this speech, I'll do two things. First, I'll talk about does their policy make the justice system more efficient? Secondly, I'll talk about which system is fairer. But firstly, does this policy make the justice system more efficient? Understand that the only mode of logic that we heard from proposition in this instance was that it's difficult to get judges to look over courts, and it's difficult to make everyone come to the court at a particular time and to have a trial. I think it's more difficult to differently interview 4 different witnesses based on which time is better for them, rather than to call all 4 witnesses on a morning and have the judicial process being done at in the same time. But furthermore, I think most justice systems are time inefficient, not because of appointment factors, but because judges are short. Judges aren't enough, or lawyers aren't enough, or there's simply more population, and there are lots of cases at the backlog, and lawyers aren't efficient in those processes. We don't think that is essentially a cause of the status quo, but that's a problem for overpopulated countries in general. But furthermore, even if I assume that this narrative is true, I still think it's worth it to have 2 extra trials to really find out whether a person is guilty or not, because you're going to lock the person away for their entire lives, or if not that, a considerable period of time. I think it's better to be safe here than sorry in trying to be time efficient. But furthermore, my second speaker gave you 4 pieces of material why government policy is more problematic. She told you, 1, that new evidence cannot come into trials when it's happening because you need to record everything anew at a different date. 2, she told you why it's difficult to have different interviews for different people, and it's easier to bring everyone into one room at a particular time. 3, it's difficult to train translators, editors, and to send all those cases after translating them to court. All this will require far more training and far problematic judicial processes, and we think time inefficiency will simply skyrocket even more. But finally, it's even harder because essentially at times you'll have miscarriage of justice being happening because you want to end everything in a quicker way. We think when it comes to justice, it's better to be safe than sorry. It's better to take time to give proper decisions rather to be haste and not to do that. All right. So in conclusion, the justice system becomes more inefficient in their world because you simply have more resources that you need to channel into this new policy, whereas the status quo works efficiently for better. All right. Secondly, in terms of which system is fairer, and I have a lot of things to say with regards to this. Understand that firstly, racist judges and juries exist. Both sides understand that. In proposition, the problem of prejudice still stays because appearance, religion, and other identity markers will still affect judgment, because you can know the race of a person based on their surname, you can know their place of origin and life history based on accents, and you will also have information about whether they belong to a minority group or not. So prejudice isn't eliminated in their world, and this is important because this is what this was where they started their case, right? But as the debate went on, the debate became more of efficiency. But given racism exists in society, how do we stop a racist jury from sentencing a black defendant to jail? I tell you that it's easier to send away a black surname to jail than a person standing in front of you in flesh and blood. Because a name or a voice in a teleprompter doesn't look into your eyes and challenge your conscience against the inert racism that exists in your own heart. It's difficult because your moral conscience does not check your racism to some extent, and you do not contemplate the consequences of prison life that you are going to put on a minority. Why is this important and why this is fair? Because the system is already unfair to begin with. Racism is an emotive factor. It cannot be challenged by factual evidence. You need something emotive in response to racism to counterbalance what happens in the mind of a judge or a jury. And we think that's why it's fair to bring emotions and subjectivity and life experience and conviction of defendants into the debate, because to tackle racism, which is already unfair, you need to have emotive elements there to begin with. But finally, what sort of changes do we bring because of this? Even if a jury is forced to double check evidence and through that process they find out that their initial verdict was wrong, I'd say that's a good outcome. If the jury is forced to not be racist because if the jury is seeing a person standing in front of them and is thinking of the consequences of prison life and is being more careful about the punishment the jury is going to give, I think that's a very good outcome, because that leads to a fairer trial, that leads to more consideration being put into the justice system in itself. In conclusion, we clearly win this clash, right? Because I explained to you, and throughout the team, we talked about why emotions are an extension to self-defense and why an emotive factor like racism deserves an emotive response from conviction of people. All right. Secondly, in this clash, I'll talk about the elements of like symbolism and the catharsis of victims, but I'll take a point of information before that.
Sir, to a racist judge who believes that a black man isn't as human as him, how do you think human conscience will play a role?
A racist judge believes a black name is easier to send to prison. A racist judge, when he sees a person standing in front of him, I think his racism is checked to a large extent. Whereas it's very easy to send away a voice or a name to prison. I think that's sufficiently explained in the speech already. But furthermore, regarding the point about victims and catharsis, right? They say that victims get traumatized in courtrooms. Firstly, victims can choose not to be present in courtroom, as explained by my second speaker. But secondly, most victims want public acknowledgement or moral catharsis. That's why they bring the case to court to begin with, because like we want a moral acknowledgement from the society, and that's why we want most trials to be public. But furthermore, they say that defendant's reputation is tainted in status quo, because the society does not recognize the principle of a person being innocent until proven guilty. I think firstly, the society in general recognizes that until a court acquits someone and sends him to prison, you can't imagine him to be a criminal. But even more, we think records are being public always, right? So like the local newspaper will report about a local hearing being happening, so that the point about tainting of reputation can still happen in your world, because court records are public and is not like an exclusive problem of status quo. But finally, the point about symbolism, and I think this is extremely, extremely important, because justice is a socially transformative right. When Slobodan Milosevic in 2002 in International Criminal Court was forced to testify in front of the international community and Serbian victims standing in the court of law, he was forced to testify to humanity of the genocide he committed. We think this is increasingly powerful when victims see and a confession from the person who violated them to begin with. We think the moral catharsis that victims gain from this being a public event is extremely empowering for victims of the present and of the future as well, because in our moral conscience, this has a very important symbolic element, something you can't replace otherwise. In conclusion, if you want fairness, if you want racism to not persist in court systems, it's very important to recognize the right of self-defense. That's why we win this debate.
Chaotic?
I now invite the opposition to reply.
One minute, right?
It's just gonna work, not iPhone.
Side proposition's biggest problem in today's debate was that verdicts will be based on physical characteristics instead of hard evidence. We told you that race and gender and these other characteristics are still available to judges through documents which are available under their model. They then responded. They said, and this isn't true, because seeing it in the document seeing that in a document that the person is black is not the same as seeing it on their face. We entirely agree, and we've explained that we agree with this from first speaker. What we don't agree with, though, is the fact that seeing that person, seeing that face in person, in any way increases your racist tendencies. We told you in first speaker, in second speaker, and we told you in third speaker just now that when you actually see, the defendant in person, even if you're a racist, the fact of the matter is that when you have to look at them, when you have to look at a person, they become an actual person, not just a name, and therefore you're less likely to be racist towards them. We think that on these grounds alone, we had no response from Team India, no sufficient response from Team India, and on those grounds, we've completely nullified the strongest or the most significant point in today's debate. On those grounds alone, they've lost. But beyond that, let's take you on a walk through the world of Team Wales and the world of Team India, and why exactly Team Wales explicitly wins this debate. What was the next biggest problem in today's debate after racial verdicts? They told us that in the status quo, judiciary systems are inefficient. We gave you four sophisticated pieces of analysis as to why that is not the case. We told you that transportation is still necessary on their side of the house. We told you that the trial is carried out at a different location from the judges and the juries. We told you that cross-examination still has to occur under their policy. And thirdly, we told you that if new evidence arises, then you have to spend more time in getting that new evidence into the system and into the judiciary process rather than just having it said right there and then. We gave you these four pieces of analysis. They had no response to this. All they did was repeat the material of the first speaker and then actually come back to us with a response to the rebuttal we gave you. We will tell you that on those grounds, they lost that clash and we won that. What else did we hear though? On our side, we told you that the problem we have with their policy, one of the main problems that we have with their policy is that more innocent people are likely to be in prison. We told you this from first speaker. We gave you structured analysis as to why this is the case, and we gave you three reasons why it's extremely problematic. What was your response, Mr. Speaker? They told us pretty much that, yes, there is more innocent people being thrown in prison, but that happens under the status quo anyways, so we don't solve it. I'm sorry, our burden in this debate was not to solve that problem, it was to explain why the problem is made worse on the Team India's side of the house. I think we did this sufficiently, we did this successfully, and they never once told us why our analysis does not stand. Instead, they tried to push an imaginary burden onto us which did not exist. We say that they completely mocked up that side of the argument, and on those grounds, they lost that argument. So what does that mean? And before I go on, and the last clash we had in this debate, we gave you principled analysis. We explained to you that that a lot of that is often very symbolic when people see the victims, people see the criminals who actually killed their family, the criminals who actually did harm to them or to society. It's very symbolic when they see that person confess to the crimes in public. Side opposition, Team India's response to this, Mr. Speaker, was that it's not always a good thing for people to see the person who killed their family, for people to see the person who raped them. It's not always a good thing mentally. We told you very simply from second speaker, we told you in third speaker as well, that fine, if you want to see the person, then you don't come to court. But the point at which you deprive that right to see the person from everybody under their policy is the point at which you make it very problematic, because now no longer can you look at the person, confessing to the crime they've done. No longer can you look into the eyes of the person who brought tangible harms to your family and the people you love. Mr. Speaker, we see that in this debate, Team India completely failed to realize the point at hand. They completely failed to clash with the direct material we gave you. But Team Wales, on the other hand, explained to you all the reasons why their policy fails in the ways it tries to succeed. We're very proud to oppose.
And to conclude the debate, I now invite the proposition to apply. She's just having some internet issues. Hold on a couple of seconds. Should be okay.
Can you guys hear me?
Yeah.
Okay, great. I'm going to start then. Over the course of 28 minutes, opposition has told us roughly 34 times that they are the side which provides a humane aspect to judgments. They've still not managed to tell us why this is. The only thing they've said more often is about how the most important aspect in a trial is what kind of emotion a judge feels as soon as they look into an accused person's eyes. We tell you that humanity rests on the side on which fair and impartial judgments are made, right? And we think we've already proved to you why this is side proposition only in this debate. They took down their own legitimacy argument when they decided to use an accused person's reputation as a form of symbolism to engineer social change, right? How do we stop racism against black people in the criminal justice system? Opposition whip still thinks that that's achieved by making some form of eye contact with the judge. We think that all of this is inherently problematic in their case. They haven't fixed it over the course of this debate. We think that's a main reason why we've already won this debate, right? They kept asserting that a black name holds less human value than a black face. We've already told you why that works the other way around too, and they refused to engage with any of that analysis. For that reason, their legitimacy argument does not stand. So now let's compare outcomes. We've already told you on side proposition why the people who are going to go to jail will end up going to jail on both sides, and why no side helps them in truth, right? It's the people who are going to be acquitted that now lie in the balance, and we tell you that the side proposition is the only side that truly helps them. We told you the benefits that accrue from these people not being recorded on camera, standing in the box reserved for an accused person in a society that often brands an accused person as a criminal, whether or not that person actually committed the crime. We told you just how important that is to these people's lives, and we think that side opposition has once again refused to engage with any of that analysis. They also refused completely to engage with our analysis about how a witness is more likely to come forward and give evidence on a case when the case is not recorded, when the case is not a case in which they are required to be physically present. We told you why victims are more comfortable on our side simply because they don't have to be in the same room as the people who assaulted them, the people who raped them, right? We think that's inherently problematic, that they have not engaged with any of this at all. They have not acknowledged the fact that we made these arguments. Another thing that they refuse to acknowledge is that delays are a legitimate issue in the criminal justice system, right? These delays often take years. We live in a country where there are criminal cases that happened 30 years back and the verdict has still not been passed. And we think that's an inherent problem in the criminal justice system. We've already told you why the time saved with each trial adds up, and that this might be the difference between an accused person spending 6 months in jail versus spending 1 year in jail. They've made the arguments about how time in jail hurts a person. We tell you that that is exactly the problem we've solved on our side, not on their side. And that's another reason why we've won this debate. So let's do some accounting now, right? So what's happened today is that side opposition no longer has an argument on illegitimacy. They no longer have any outcomes. What side proposition still has is 4 outcomes on why the accused and the victims are better on our side. We've already so told you why this criminal justice system is way more unbiased and way more efficient. For all these reasons, we think we won this debate. We are very, very proud to propose.
Hey, George. I can't
He needs to unmute. Yeah.
Got it. Okay. Can you hear me?
Yeah.
Okay. Well, thanks so much for that. And can your team hear me as well?
Yes.
Okay. Well, congratulations, guys. I thought those were excellent speeches. I'm going to head off and shout at my kids for a bit. I guess speak later this evening and perhaps do this again soon.
Yeah,
Yes.
definitely.
Yeah, definitely.
Thanks a lot for the start.
Well, thanks very much. Thanks very much. It's really kind of you to give us the chance to practice.
Let's definitely do this next week and also, Josh.
Thank you so much.
Do this next week and also.
No problem. Well, see you soon. Thanks again.
Okay, thank you. Bye bye. Take care.
Team Wales.
Bye-bye.